reminder that the cases, unless the court has put an order down otherwise, the oral arguments are live streamed on the Administrative Office of the Court's live stream site, I guess, and that then will be posted on the AOC YouTube site so that the public can review them. Call the first case, please.
Robert L. Davis et al. Versus Karen Edwards.
Good afternoon.
Good afternoon.
May it please the court, I've reserved 3 minutes, please.
3 minutes?
Yes, sir.
That'll be fine.
I'm Josh Jenny of the Bradley County Bar. Pleasure to be here as always today on behalf of the substitute appellants, Mr. and Ms. Joe Hamby. As an initial matter, may it please the court.
If you would pull the microphone down just
Too far
a little
from
bit.
Thank you for letting me know, Your Honor. As an initial matter, I would like to hand the court a visual aid or demonstrative item. If Mr. Nord has no issue, it's really just an attempt to provide a visual aid and perhaps inject some excitement to the extent possible into an easement issue. Just aerial images of the land at issue, should the court find those amenable.
Were the exhibits placed to the trial court?
The record contains a plat, Your Honor, and I think a street view. I was simply bringing something in case the court wanted to see it that just kind of shows an aerial visual of the land that we're talking about on both sides of the case.
Do you have any? I don't have any. Okay. Yes, if you would get those and get them up, take those and get them to us, please.
And just for quick reference, the first page is a historical image showing the two tracks at issue before the driveway, the basis of the lawsuit was constructed. The second image does show on the bottom right-hand corner a rough depiction of the driveway as constructed following the litigation. And then the third page is simply a tax map or GIS map from the offices of our local assessor showing the tract owned by my clients. As conceded in my brief, the issue about the consideration, the existence of a verbal agreement, and the items that made the basis of the underlying claim and lawsuit are really not at issue on appeal. That because Ms. Karen Edwards, my client at the trial level, had constructed and built the driveway in accordance with the trial court's order by the time we rolled around to having a hearing on post-judgment motions. The issue before the court today is whether or not the trial court erred in terminating the express easement appurtenant that was set forth as Trial Exhibit 3 and entitled Driveway Easement and Maintenance Agreement. I typically don't like to give a long recitation of the facts, but essentially when my client's predecessor, when Ms. Karen Edwards' predecessor in title was still owner of the property, named Jeanette Schlager, she decided to sell. And when she decided to sell, as the record reflects, title company, closing agency, or mortgage lender required and wanted some confirmation of the unwritten easement rights or access rights that had been in place for 40 or more years. And the culmination of that discussion and that issue resulted in Trial Exhibit 3. And what I'd like to point out initially to the court is that nowhere in this document, the easement and maintenance agreement, is there any reflection or use of the word temporary. There is no recitation of any terms that would lend one to the belief or the interpretation, in my opinion, that it was in any way to lapse or be extinguished. Rather, it expressly states the purpose, the location of the right-of-way, and that the same would be perpetual in nature, permanent, and subject to passing to all subsequent owners and holders of deeds thereafter. That would include Ms. Edwards. That would include Mr. and Ms. Hamby, in my opinion.
I've got a question for you, and I understand your argument certainly about what the language of the DEMA says, but I mean, now that your client has built her own driveway off of Highway 11, why does she still want or need the easement?
I assume that question would come up, and I'm going to try to get my answer within the confines of the record. In opposing counsel's pleadings that are in the record, I think there's discussion about the fact that a non-party to this case, has purchased the tract down here at the bottom right-hand corner of the first and second pages. There's going to be some question, I think, as to whether the constructed driveway imposes or violates any setback restrictions, but that's not an issue or lawsuit pending, nothing before this court. And otherwise, I think this is part of the record too. The topography is not something that was ever ideal, simply because when you get to the top of what I'll call this ridge, which is just to the east side of the 8361 address, it's steep, I guess, for lack of a better word. It's steep going up and then an embankment back down onto the driveway that was existing over the long-standing right-of-way. The court's question may be more in tune or in line with the question of, is it still an absolute necessity? It is passable. It is used. The concerns that she had were more so related to mailmen, emergency vehicles, fire trucks, Amazon delivery drivers, and things like that, who, if my understanding is correct, had voiced some difficulty with navigating that ridge. I proceed, Your Honor?
Yes.
Okay. Interestingly, the issue really didn't come up until after the trial. In my brief, I cited or recited two portions of the transcript, and where trial counsel at the time, Mr. Andy Brown, plaintiff's counsel, started out by saying, and I'm referring to page 15 of my brief, says, Mr. Davis showed up. He gave his testimony that he didn't even read it because he trusted his wife. So he signed the agreement, which conveyed a perpetual easement to Miss Karen Edwards from this roadway, henceforth and forevermore. There were questions asked, and they were also cited in my brief, where it's made clear that Mr. Davis, or the plaintiffs, understood that were they successful in the underlying lawsuit, their claim that there was a verbal agreement and a requirement for my client to build an additional driveway, that would have absolutely no effect on the existence, the nature, and the purpose and available use of the long-standing right-of-way from Highway 11. At the end of the case, we received the final order, and the court, trial court, for whom I have great respect, set out a statement of the issues, and they included, was there a verbal agreement that's enforceable? If so, was the verbal agreement breached? If so, how long should Miss Edwards have to construct a new driveway? And, otherwise, has she failed to comply with the whatever were the terms of the verbal agreement? There was no prayer for relief that included a request to extinguish the right-of-way, and there was no statement of the issues presented to the trial court during the underlying proceedings. It came up, as a matter of fact, if my recollection is correct, in the plaintiff's post-trial motions for additional findings. And so we kind of jumped from having the underlying trial conducted and having the benefit of the court's ruling on whether or not there was a verbal and enforceable agreement to a situation where the court goes on to say that the intention was to find that the old right-of-way or old easement would be extinguished upon construction of the new road. And as indicated very respectfully, I don't see that as a word of mention in Exhibit 3. There was no testimony outside the document itself or in the record that would lend itself to the conclusion that it was some type of condition prerequisite or subsequent, or that there was any contemplation at all the right-of-way would ever be extinguished. And so, with the property now being in the hands or conveyed by deed to Mr. and Ms. Hamby, they're certainly interested in maintaining and do not wish to waive or abandon their easement and access rights, and that's the issue we're asking the court to look at on appeal. Unless anybody's feelings will be hurt by me saving some time, I'll turn it over to Mr. Norwood.
You have your time for rebuttal.
Your Honor, I'm Rob Norwood, also of the Bradley County Bar. I did not try the case. I was involved in the post-trial motions, and so a little late coming to the case, but I think that what happened is this. One thing I want to mention to the court, the appellant has cited the wrong standard of review. They say it's de novo. The appeal was of the order allowing the motion to alter or amend, and so it'll be abuse of discretion standard, which I understand is more deferential to the trial court. And so for that one little thing I wanted to discuss is, I think the trial court got this right. These folks were not related. Miss Edwards, the appellant, came to my clients and said, I want to buy your sister-in-law's property across the street, but I have to have a written easement to do that to satisfy my lender. And I'm going to build my own easement. I'm about to build my own driveway within 1 year if you'll do that for me. And they did that for him. Obviously, the document that was signed is a perpetual easement. It's not, doesn't have the caveats. It was presented to my client. It was signed. But with regards to that, the findings were this. For a year after she moved in, there were still efforts to have her do what she was agreed to do, what she promised to do, to build her own driveway, but she didn't do it. That's what brought about the suit.
Oh, Counsel, let me ask you a couple of questions
Yes, sir.
about this. At the start of the trial, plaintiff's trial counsel, your predecessor, did they state that one thing that's not at issue is just a set of circumstances based on the parties' agreement? We are not asking that the perpetual easement be set aside, the one to the Davis's property. It exists as it is written, henceforth forevermore consistent with those terms.
I understand what you just read to me.
Yes, and that was
and-
said, wasn't it, to the trial
And
court?
I understand that, but that's not exactly what was tried before the court, and that's certainly not what the court found.
Well, I
with regards
understand
to
it's
that.
not what the court
proof was
found.
different.
But my question to you is, what relief were the plaintiffs asking for?
Well, that time they wanted to make the easement be built, where they didn't have to use the temporary
Well,
easement.
okay. I'm trying to see how these are connected. One is an easement.
Let me call it a
and it's-
driveway.
The right of way, I understand, okay, whatever you want to call it. The second one was the supposed promised one to Ms. Edwards' house. How does the requiring the new driveway to be built, where anywhere does that show in the easement that it terminates the first right of way?
It doesn't show it on the written easement itself.
And
There's
the trial
no
court
reflection.
and opposing counsel are told that they're not asking that the perpetual easement be set aside. I mean, how was that tried?
It was tried on the fact that they want to enforce what was actually promised by the appellant and by the plaintiff, the defendant in this case, Miss Edwards, who said that she was going to build her own driveway, in which she ultimately did. And so the idea that once the driveway was built, there was no need, there was a nullity with regards to the temporary easement. She didn't need it anymore. And so in that regards, that's what my reading of the record is.
I understand that was the position that was taken there, but I guess I'm troubled by the fact that we're told, no, this is a perpetual easement forevermore. And then somehow or another, the trial court finds what you said, that this really was just an agreement that this perpetual easement was going to be a temporary easement. And she was going to have to build a drive. My difficulty, and maybe just mine, is understanding why the requirement to her agreement, say, to build the new driveway to her place, how does that get rid of the other easement?
Well, with regards to that, Your Honor,
Maybe she doesn't need it anymore, but how does it get rid of it?
she doesn't need it anymore. She wasn't using it, but more importantly, they went to the trial on this matter. I got involved after the trial. They being the appellants filed a motion to alter or amend that sat in the trial court for 15 or 16 months. These folks came to me and said, what can we do to get rid of the easement? I said, well, the court's findings look like he got rid of the easement. So we need to file a motion to alter or amend. And that's what I'm asking the court to do. They've waived these issues. And let me tell you why they've waived these issues. They filed a motion to alter or amend based on consideration, which they've now said wasn't really a particularly viable argument, and they struck that motion. They didn't argue that motion. My motion to alter or amend, there was no written response to it. And so what I'm asking the court and what I'm suggesting to the court, that issue was briefed, that issue was provided to the court, that issue was orally argued, and there was the issue that you've just brought up to the court, to my attention, that there was some agreement previous that there was not going to be any argument about the easement. That's what was at issue. And so, and my belief is that the appellant has waived these arguments by doing one. One, they didn't prosecute their motion to alter or amend. They struck it. So the trial court didn't have a chance to correct that, never brought it to the trial court's attention. Based on my motion to alter or amend or to find additional findings, the court made those additional findings. They didn't file a response to that. And so they've waived this issue with regards to being in front of this court, because if the court's issue that the court's presenting to me right now should have presented to the trial court for the trial court to have done something. It could have said, wait a minute, look back at the record. This is what we were trying the first time. But that wasn't done. So what was actually agreed to, in essence, they didn't object to that. So my suggestion is this, is they were represented by counsel. They were here, and my motion was made to alter or amend to make some additional findings which were consistent with what the trial court agreed to.
What were the specific findings you asked and then the court adopted?
I asked the trial to find that it was a temporary easement, and also to find that it no longer was being used and it lapsed, or it was a nullity, and that's what the court did find. And so in dealing with what the court's got an issue with in this regard, those issues were in front of the court, and there was not any resistance to that. And so that's what was presented, that's what was tried in front of this court, and that's what was found. And so that's why I'm suggesting in this case there's not an issue on appeal, because their issue on appeal is this: whether the trial court erred in terminating the appellant's driveway easement rights expressly provided by the driveway easement and maintenance agreement. Well, in the motions to alter or amend, which is what they've appealed from, the trial court didn't address that issue. That wasn't presented to them by the appellant. The trial court should be having an opportunity, if there is an error made in the trial court, they ought to be able to address that. That's why you have it before you get to this court.
Well, that's not a requirement in a bench trial, is it? You don't have to file a motion to alter or amend.
But they did file a motion to alter or amend, Your Honor.
They could. Well, I understand, but it wasn't hard. Let me ask you another question that troubles me some about this.
Yes, sir.
I sound like a country music song that troubles me some. But it's your position, and I think the trial court found, that this really was a temporary easement. Was that correct?
That's correct, temporary easement.
And it was written up and executed to allow Ms. Edwards to go to the bank and present it as a permanent easement so she could borrow money.
Or she could purchase the property. Correct.
Yeah, she needed to get the money from the bank, I think that was all the testimony, wasn't it?
That was the testimony in the court.
So both sides, you're telling me that both sides agreed, let's draw up this fraudulent document that's really a temporary easement, and we're going to say it's a permanent easement, so you can take it to the bank and use it to get your loan.
No, sir. And
Why not?
I understand if both parties signed it. I understand what the law implies by the fact that it was signed and reviewed. I understand that. But no, this was something that was prepared by the appellant, presented to my client, and they signed it and gave it back to him. And the idea that they didn't read it, I understand that ramifications of that. But there was no attempt by the Davises to somehow perpetrate a fraud on the lender or something to that nature. They didn't gain any benefit from that.
The person that originally sold the property, was she related? I can't remember her name, and I can't pronounce it. It's
her sister-in-law.
Sister-in-law. So there was a family relationship there.
There was a family relationship.
And she was wanting to sell her property.
Her husband died, which is my client, Layla Davis's brother.
Yes.
And so when he died, there got to be, according to their arguments and the things in trial, there was a contentious nature about the easements even at that time. And so my clients wanted to get rid of the easement even back when it was the sister-in-law's use of it. That's why it's to the sister-in-law, because the sister-in-law is the one that sold the property to Mr. and Ms. Edwards, or to Miss Edwards. And so at that point, with regards to that, this was a contentious thing. My client didn't want to give this easement at any time. And certainly, it was only because Ms. Edwards came forward and says, I can't buy this property without you providing us an easement. There wasn't any description about what kind of easement, whether it was going to be just for her or run with land or any of those things. And most people don't know those things. But there was an easement presented. My client did sign it. It was recorded. I'm not disputing that. But what I am suggesting to you, to the court, is what was actually tried was this a temporary easement? Was it intended a pledge based on a condition subsequent? Because that's what it was, a condition subsequent. You're going to get the easement, and you're going to build your own road on your property. Justice Davis asked the question why we're here, and I understood that. That's a pretty good question. Because she sold this property for a $500,000 profit shortly thereafter. But if the court will look here, the problem is Miss Edwards didn't build her driveway completely on her property. You can see it goes on an adjacent tract, 52.03, and I realize this is a tax map and these lines are not perfect. But that's why we have another party here. They don't use this. The argument that 911 had problem, they have a problem with using a brand new road that goes directly back to her property. That's not what we're looking at here. The problem is, and why we're here, is they built it partly on somebody else's property. It's not much. And that's why you haven't seen a whole lot of arguments about this easement until the new owners got it. And so what I'm suggesting to the court is this, and I may not have done a very good job of it, and I'm going to try to do a little better, is that these parties came together and tried this case. The issues were found against Miss Edwards. They found that she was not credible, that the agreement of the parties was just this. It was going to be a temporary easement. It was going to be a period of time that gave her an access way to her property until she built her own road. She then built her own road. She hasn't used this temporary easement since that time, and neither have the people that are now the plaintiffs or the appellants in this case. They haven't used this easement. And so the findings of the court are not only consistent with what the testimony of the parties were at the party, that it was a temporary easement and that it would at some time end. And there are certainly cases that I've asserted to the court in my brief with regards to these, when they're an easement with a subsequent condition or another term, they are considered temporary easements. And that's what I'm suggesting this time. And I do believe that with regards to the concerns the court has, and the court has verbalized them to me, they've waived those situations by letting their motion to amend be stricken and my motion to amend to be granted without response. That's what I'm asking the court, is to deem that there's been a waiver of any issue, the issue that they have in this regard, because the trial court was not given an opportunity to truly address that. Thank you.
Thank you. Hear from the appellee in rebuttal.
Thank you. Just briefly in response to some of counsel's comments. First of all, Mr. Norwood made reference to the 15 or 16 months or so that lapsed between the time of my post-trial motion and the hearing. I think this is contained and set forth within both of the post-trial motions, but following the trial, my client dealt with a situation where her husband, with whom she was attempting a reconciliation, ended up becoming her divorced spouse. Her father passed away, and she began to care full-time for her mother during the same time period. And so candidly, her time, attention, and funds were, in my opinion, understandably devoted elsewhere. And that kind of touches on Justice Davis's question about the need or access and my reference to ambulance service capabilities. The court also asked the question about whether or not these folks are relatives, and as Mr. Norwood correctly indicated, Tony Schlager and Layla Davis were brother and sister. When Tony died, issues arose such that, and this is also within the record set forth in my answer, and I think the trial transcript as well. I filed a lawsuit styled Jeanette Schlager versus the Davises in an attempt to regain this access, and that suit ended after Exhibit 3 was executed. And I'm getting a little bit off topic because...
Counsel,
Yes.
sorry to interrupt you before your time runs out. Trial court questioned Edwards' credibility, correct?
Yes, sir.
What was the purpose of this supposed agreement that she would build her own driveway if it wasn't to get rid of the document that the Davises had signed, make it treated as a temporary easement?
I think her testimony was that she thought that she had to, and that corresponded with her answers to requests for admission, that she had applied to TDOT and gotten some drainage, and she thought that she had to build the right-of-way. That was about the time that the lawsuit between Ms. Schlager and the Davises was resolved, and I started asking the question, well, what is this? Your name is specifically mentioned in Exhibit 3. She's not a signatory, and I don't remember if she testified as to when she first gained knowledge of it, but I think the court had a little bit of a problem with her stance, which was I did approach the Davises, and I told them that I would construct a driveway, and then I was later made to understand that that was not necessary given the permanent perpetual easement, permanent exclusive easement that was recorded in the Register of Deeds office.
Well, what was the purpose of her telling them, I'm going to construct my own driveway,
Subject, you mean
but I want to keep this permanent easement I'm going to ask you to sign?
Well, I think there's two answers. The first one is, subjectively, she believed that she had an obligation, and the court found she had an obligation based on the verbal agreement to proceed with the construction of the new driveway.
Why would they care if she built a new driveway?
I'm sorry?
Why would they care? Why would the Davises care if she built a new driveway if the easement was still going to be there?
Well, I would refer the court to the transcript that's attached to our post-trial motions in the court's order. Mr. Nord's term was silly or silliness, and the turning over of stumps and putting trees down to block the road, and Hatfield and McCoy type situation is why the right-of-way that existed needed to be preserved, and why derivatively she was ordered, I guess, to build a new driveway coming from Highway 11 over that flag portion of the lot.
Was that what the court just originally ordered, was that she built a new driveway?
Yes, sir, within 90 days.
Did the court say anything about the easement?
Not to my knowledge, Your Honor.
And that was but then the court addressed it when he asked on the motion to alter or amend.
Yes, sir. My motion to alter amend was asking the court for additional findings as to the consideration. I was arguing that Exhibit 3 was consideration for the dismissal of the first lawsuit, not as consideration for...
But the Davises filed a motion to alter or amend too.
Yes, sir. Then Mr. Nord came in and also filed a Rule 59 motion, and at that point in time, it was injected for the first time in my assessment, even the request or the issue as to whether or not the permanent easement would be in any way affected at all.
Okay. All right. Thank you.
Thank you very much. And should I leave my maps to the court or take and dispose of those, whichever you prefer?
You have any objection with them leaving this here?
No, sir.
Okay. Yes.
Thank you very much.
Well, we understand that we're an exhibit at the trial court. But our thanks to counsel for both sides. We appreciate your argument and your briefs on this. And y'all have a safe drive back to